It is time to check in with Chris Dimakos. He is our CJAD 800 legal contributor. Chris, interesting story this week, which applies, I guess, and that's going to be the point of us talking about this, pretty much across any workplace. The specific story you're suggesting here deals with a coach, right, at university who was terminated after receiving not one or two, but 30 complaints for his style of coaching, which is interesting, right? And that includes yelling, screaming, demeaning players. And the court actually sided with him. So bring us up to date on this story and how this might apply.
Yeah, so very quickly, university coach has a certain style, a very, let's just say, vocal. He screams a lot, throws balls against the wall. And the girls' volleyball team that he coaches, some of those players had problems with that, and they filed complaints. So the university hires an independent firm to do an investigation, and they find that the coach, of the 30 accusations, made nine mistakes that shouldn't have happened. And then the university decides to fire and terminate the coach. And they went to court, and this is what's important for the listener. When they went to court, the court did not say that he didn't make any mistakes. The court said he did make mistakes, but those mistakes didn't merit being fired and terminated. They should have offered him a chance to correct his behavior. And because of that, it was deemed an unlawful termination, and he received about $50,000 in severance. So what's important to take here for everyone is just because you make a mistake or just because your behavior or your performance is not up to snuff and doesn't meet standards, the automatic termination is not always the answer. The employer has to provide an opportunity for you to correct that behavior. Okay. And that's a perfect example here where no one's questioning whether he did a mistake or not. They all agree that he should have not done that. The question was, should the university have fired him or given him a chance to correct and go through training and make his adjustments as needed?
So my question here is, we had never during this entire rundown discussed whether he was doing his job or not, right? He was the coach of that team. They didn't like his style and let him go by virtue of that, not by virtue of the fact that he didn't do his job well or wasn't a good coach.
Yeah, the actual results of the coaching were not play. It was more so the complaints by the players. Some of the veteran players, for example, were told that they would have to earn their spots the next year. They didn't like that apart from his style, so they filed complaints. But many other assistant coaches said that he was very brash and he would, demean people in the way that he would talk. And all of that conduct, it's not a question of whether or not the court felt it was appropriate or not. They all felt it was inappropriate. Everyone said that he did not perform the way he should have. The legal question was, does that merit an automatic termination? Right. Or does it mean, hey, you're not doing this right. If you don't change this, and we're going to give you a chance to, well, then you're going to be let go. And that's the key there for everybody. You have to have that sit down with your employer and saying, this didn't go well. You're not doing what we expected. Right. You have a chance here to change.
How can I fix it? And if you fix it, then you're back. You're okay.
Right. Exactly.
Okay. The other story deals with something that I'd never heard of before, but I'm guessing it's called a performance improvement plan. This is something that Amazon basically told a worker that he would have to do. What's the story?
Right. So if you want to tie both in, if the university would have told the coach, we're putting you on a performance improvement plan. Here's where we want you to improve. Here are your objectives. If you don't, well, then you'll be terminated. Okay. Same thing happened here in Amazon. An employee was put on a performance improvement plan. And traditionally, these are the last step before someone gets terminated. And they are done because the employer wants to say, hey, Judge, we did our part. We gave the opportunity to the employee to correct their behavior, and they didn't. So in this case, the employee said, no, I'm not going through with this. You're just trying to push me out the door, and they went to court. But what's really important here, and Amazon was found to be, they won the case, they had it dismissed. And what's important here for everyone to know is when you're being put on a performance improvement plan, it's not always done genuinely. Sometimes companies use performance improvement plans to push you out the door just so they cover their liability. And what you need to do as an employee, if you're ever put on those plans, is make sure that the performance improvement plan, first of all, represents the truth of what's going on, you're allowed to have a debate about that and whether or not you achieve your objectives. But the second one, which is the most important, is which I advise everyone to do, is make sure that the objectives are quantifiable, not just interpretation. You want to get away from, I want you to have a more positive attitude. You need concrete objectives that can be evaluated and not just rely on someone's opinion on whether or not you're doing a good job. So, again, Amazon did their homework. They did things properly. But for everyone who's had a meeting with their employer who's saying, you're going to be put on this performance improvement plan here, and this is the last step. If you don't do this well, we're going to have to let you go. Make sure whatever's in that performance improvement plan, first of all, is right and just and not something that's been fabricated. But secondly, that you can be able to demonstrate after that 3 months that you achieved those results. And it's not let up to someone, a superior, for example, who gives their opinion on whether or not you've achieved your objectives.
By the way, do you have any way, if this happens to you, you're put on this, what we'll call this performance improvement plan, to negotiate that plan as to what you need to change, what you don't need to change, or do you just have to follow it verbatim?
Absolutely. And this is a major point of contention that many people have because they realize that you're on the track to getting let go. When you get put on these performance improvement plans, and they're very, very common right now, what big companies do this all the time because they want to show that they gave an opportunity for the employee to correct their behavior. What you want to make sure is that in that plan, that there's no misrepresentations of what's happening. For example, I'll give you one case that I had where they talked about his sales being lower than his historical sales, but they didn't mention the fact that they just changed his territory of what he was covering, where he was put in a brand new territory where the company was not known yet. Obviously, his sales wouldn't match his previous sales. So it's important that you make sure it represents the reality of what's going on. And second, make sure those objectives are attainable and they're fair and they're in line with what the company expects from other employees. So it is a time, you're absolutely right, Aaron, it is a time to negotiate and it is a time to, make sure that you make comments on objectives that are unrealistic, that are not equitable, and if you feel like they're just trying to build a case against you to be able to throw you out without providing severance.
So just as a final question, Chris, so you've dealt with this. Do you find employers willing to do this?
So the employers that are genuine in what they're trying to achieve, absolutely. The ones that are using this as a tool to push you out the door when the reality is you don't merit being terminated, those employers are less likely to do so. And you have to be able to demonstrate that at that stage. If you're going to be going to court after it and contest your termination, you have to show that the employer wasn't willing to be reasonable at that time. And it speaks to the credibility.
Chris Dimakos, our CJAD legal expert. Chris, thanks so much. Appreciate it.
Thanks, Aaron.
Canadian women are looking for more out of themselves, their businesses, their elected leaders, and the world around them.
And that's why we're thrilled to introduce the Honest Talk podcast.
I'm Jennifer Stewart.
And I'm Catherine Clark. And in this podcast, we interview Canada's most inspiring women.
Entrepreneurs, artists, athletes, politicians, and newsmakers, all at different stages of their journey.
So if you're looking to connect, then we hope you'll join us.
Listen to the Honest Talk podcast on iHeartRadio or wherever you listen to your podcasts.